3 reasons it's a bad idea to wait to set up your estate plan in Florida. If you've been putting off setting up your estate plan, you're not alone. But waiting could have serious consequences for you and the people you care about. Hi, I'm Nick Carroll, an estate planning attorney here in Florida, and today I'm going to tell you 3 reasons why it's a bad idea to wait to do your estate planning. Life is unpredictable. Anything can happen. Recently, I had a client who they did a consultation with us. He has minor children. His wife is a stay-at-home mom. He was really concerned about if something happened to him, what's going to happen to his family. So we met around June of last year. We did a consultation. He wanted to move forward. He signed the representation agreement. We prepared the drafts. We sent it to him to review. He approved it. But then he kept rescheduling his signing appointment. The signing appointment is the last step in the estate planning process where the client signs the estate planning documents. This particular client rescheduled his appointment like 4 or 5 times. And one day we got a call from his wife telling us that he passed away in a motorcycle accident before he could sign his estate planning documents. And because of that, his family had to go through probate court to get the assets transferred from his name over to the name of his wife. Additionally, we had to establish a guardianship for this client's son because in Florida, if a minor child inherits more than $15,000, a guardianship is necessary to hold that child's inheritance until they're 18. So this client could have paid $3,000 or $4,000 for an estate plan that could have helped his family avoid the tens of thousands of dollars in probate and guardianship fees that they had to pay. All because he waited, he thought he had time to get this done, but life is unpredictable. It's best to not procrastinate and just get it done. A second reason not to wait is because if you don't put your wishes in writing, the government will decide what happens to your assets. In Florida, if you don't have an estate plan, the state has a default order of who gets what. It depends on your marital status, whether you have children, whether your children are from your marriage, or whether you have stepchildren. All those factors and many more can influence who eventually gets your assets if you don't have a plan in writing. This is of special concern with blended families. I had a client who was on his second marriage. So he had children from his previous marriage who were adults, and he had a minor child, an infant, from his second marriage who was just starting out in life, 2 or 3 years old, and he had a young wife as well. We met, very similar story to the first one. We did a consultation, we set up a trust-based estate plan design, and he told me he wanted to think about it. So the ball was in his court to kind of say to me, all right, I want to move forward. The plan involved setting things up so that if something happened to the client, his wife would have control of everything for the benefit of herself and for their minor child. He said to me that his adult children from his previous marriage didn't really need anything because they were already independently successful. So he wanted everything he owned to go to his wife and his infant child. Unfortunately, as you could probably guess, this client also passed away before he could finalize his estate plan. Unfortunately, his spouse, his wife, had to go through probate court to get the assets that her husband had. However, because he did not have a written estate plan, Florida's default intestate succession rules applied. And what happened was his wife received 50% of his estate, and his infant child had to share the other 50% with his 2 adult children. So that was an unintended consequence. He wanted everything to go to his new wife and his infant child, but that didn't happen because he did not have a valid estate plan when he passed away. On the other hand, if he had just completed the estate plan, his wife could have avoided probate completely. And his infant child, who really needed the assets and support, would have been fully provided for instead of having to share the inheritance with the other adult children who were already financially independent. A third reason not to wait is because if you do wait and something happens before you can complete your plan, your family members and loved ones might be left with a huge financial burden to handle. And it can be very stressful, especially if you have a complicated estate or a complicated family situation. I've had several grieving widows and widowers in my office. Their spouse just passed away. There was no estate plan. The mortgage needs to be paid, taxes need to be paid, insurance needs to be paid, and the surviving spouse doesn't know how to deal with it because the other spouse was responsible for the finances. So if you don't plan, a risk is that your spouse would be in that situation. And it's so easy to avoid that just by taking some time to meet with an estate planning attorney, discuss your situation, your family, your assets, your loved ones, what you want to happen. And it's possible to come up with an estate plan that can avoid probate and ensure that the transition of wealth is streamlined and efficient, cost effective, so that you and your loved ones can have that peace of mind of knowing if anything happens to you, at least you took the time to set up a written, enforceable plan to make that process as easy as possible. Like I said, life is unpredictable, and that's why you need to set up an estate plan as soon as possible. Click the link below to book a free consultation call with us.